Welcome to Legalese. My name's Christopher Lilly. I'm the host of Legalese. Legalese is designed to bring topics of interest to the community dealing with laws in Massachusetts, the local laws. Today's topic is adoption law, and I'm joined today by attorney Andrea Wells from the Levitt Law Group. And Andrea, thank you for being here.
Thank you for having me.
Andrea, why don't we start by talking, well, we're going to be talking about the adoption process. We're going to be talking about the various ways in which people find themselves in the adoption process. One of the things I was looking at, and I don't do adoptions, clearly this is an area of expertise for you that I'd like to have you talk about a little bit, with respect to the fact first that this state of Massachusetts is referred to as an agency-based state.
Correct.
What does that mean?
So an agency-based state, and there aren't too many of them, requires that adoptions go through the Department of Children and Families or a adoption agency that's authorized by statute to assist and facilitate the adoptions. So what that means for the average person is that it is not, there's no private placement. Sometimes people who are in the adoption process or beginning it will see that there are many websites, there are a lot of adoption facilitators nationally that identify, they might advertise for adoptive families, they might make a video of a family and is hoping to adopt, and they also sort of recruit expectant mothers to place their children. So that similarly can work here, but if you do it that way, you have to be working with an adoption agency.
All right. Who are the various, what are the various scenarios that you see that may lend itself to adoption?
So some, obvious reason that people come to an adoption is they either want to add to their family or they want to start their family. Sometimes people are coming from having already had biological children. Sometimes they're coming from fertility failures. But in any event, sometimes it is because it's a family member. They might have I see many grandparents whose children may have their own children, but they're unable to care for them due to often it's addiction issues. So those are, there are different ways that we go about establishing an adoption. So we talked about the Department of Children and Families. So you can be placed, the Department of Children and Families can place you. So people who are hoping to adopt could go through the Department of Children and Families and say, I would like to be an adoptive parent. They would go through the training, foster care training, and hopefully a child will be placed with them and it develops from there. What I was talking about with a grandparent or another blood relative can also petition to adopt a family member. And in all of these adoption situations, the petitioner, that's the person who wants to adopt, has to be 18, and they can only adopt someone who is younger than them. So you could be 65 and adopt a 50-year-old. It doesn't happen very often, but it could.
Really?
Yes, and I have seen a situation where an adult wanted to be adopted, even though she was, 28 years old, because she had been raised by a certain gentleman, and they wanted to give legal effect to that. So. And
what is the legal effect that's ultimately given to that situation?
Well, so you have inheritance rights. I mean, at that age, there's less responsibilities for an adoptive parent than if they're a child. But and again, I think some people, it's like getting married. People feel like that piece of paper means something. It's a commitment, and that was important to them. So it can happen. But so you can be placed. A child can be placed by Department of Children and Families. You can have a blood relative petition to adopt. A step parent can also petition to adopt, and that's probably what I see most frequently.
Okay.
Or you can have to have the approval of DCF. So, and they can be placed by an agency as well, not just Department of Children and Families.
All right. So let's start. Let's go from the point of view of a step parent.
Okay.
A step parent who has now married into this family, knows the child, as you may not know in other scenarios where you're looking to adopt a child. You don't know who that child is going to be as you come into the situation. But you're the stepfather of this child, you're the stepmother of this child, and you want to adopt. Right. What is the process? What happens at that point?
So in all adoptions, kind of that first threshold is you want to have parental consent. and by that I mean the natural parents, or if they had previously been in adoption. But those parents need to consent. So in a step-parent situation, it's possible that the other parent has died. So obviously we don't need their consent at that point, and it's much more simplified. If the parent is present, in most situations where if they're not willing to consent, they may not be present. They may have abandoned the child, moved away, maybe not paying support. They could be of parts unknown. Again, sometimes it comes to some of the deficiencies of parenting that can come from drug or alcohol addiction.
Sure.
But if you are able to get that consent from the other parent, you file the petition for adoption. Both the natural parent that is still there joins in that petition. You can adopt your own child with the step parent. You file that petition. There are a number of documents that you have to fill out with the court. The other parent is entitled to notice if you don't have their consent, you don't know where they are. Ideally, you're able to get in hand, meaning if they're in state, you have to try for in hand. Out of state, it's still ideal if you can get it. If you have an address, you should try, and I always advise my clients, try as best as you can to give them actual notice. But if that's not possible, the court would order notice through publication, which is somewhat of a fiction in terms of it might be the local weekly paper. It's not going to be the Boston Globe or the New York Times. They'll try to do it locally to where they believe that parent is, but those aren't always the people who are reading legal notices in the paper. But you have to publish, 3 consecutive weeks, and that is considered under the law to be good notice, even if it's never seen by that parent. So the court then will give you a, quote, return day, and if that other parent doesn't file an objection or an appearance with their counsel, then the court goes through its process with, you would typically, in a step parent, ask the court to waive the home study being a investigation by DCF or the adoption agency. But you can waive the home study if the court allows you to, and they typically do allow you to waive that. And there are a couple other steps they take, but mostly you end up with a court hearing, and at that stage it is all been approved, and it's really more of a celebration than a court hearing as you and I might think of one.
Right.
So so it's very nice when it comes together and it works for everyone, because it is one of the happier events in a family law attorney's experience to balance the sometimes emotional.
One of the few cases in probate court that you see people smiling.
Right. And you see cute little kids all dressed up.
Yes, you do see that.
Yes.
So when we're talking about lack of consent or obtaining consent, that lack of consent that you may have to try to overcome would be a scenario where you're unable to find that parent in most cases.
Right, or sometimes they do know where this other parent is, but they haven't contacted the child in years, no birthday card, no telephone calls, and sometimes the child really doesn't know who that other parent is. They've been absent for so long, and if you lose your parent when you're 2, you just don't recall them, so they have no relationship. But the present parent may still know where they are, have some communication, but they can say, no, I'm not going to agree to it, and I have had many cases where that was the case, where they say, I'm not going to agree to that. But at the end of the day, they don't file with the court, and it goes through.
Let's say we have a situation where a parent either has been somewhat hands-off but is now saying no, or a parent that has been less hands-off and is saying no. What do you see unfolding as far as that when that parent asserts an objection to this adoption going forward?
Right.
What then has to occur?
Well, in many cases, the present parent, the step parent, they don't pursue it because it would be such a challenge at that point for them. Many people don't have the means to wage this extensive legal battle. Sometimes they are still able to negotiate with the other parent in terms of allowing some continued contact, not that it would be inappropriate to sort of entice the other parent, but sometimes if there's a support order, that is an enticement for that other parent to relinquish their parental rights so that they don't have to pay child support going forward. So those are the kind of things that sometimes the parents are talking about to see if they could make it work. Sometimes we can look at other ways to have that step parent involved. One of the reasons for doing an adoption is so that that step parent, for example, would have legal decision making, could, in an emergency, could authorize medical treatment, things that nature that if you don't have that relationship, you legally can't do. So we can look at guardianships, things like that. So, but it is a very different animal, and it's very much similar to what you would see if the Department of Children and Families was coming into court and saying this is an unfit parent. And that's really what you have to demonstrate, and that can be hard to do. But the court looks at, in their DCF cases as well, has the child been abandoned? Has there been a failure to support them? Has there been drug and alcohol? Has there been abuse? All of those things. But they're essentially looking at both parents and the petitioners, their fitness, their ability, their capacity to demonstrate parental responsibility and willingness and ability to take that on. So
It's almost a straightforward custody.
yes,
dispute.
it does look a lot like a custody case, but it's more of it's a higher standard. So DCF needs to show by clear and convincing,
Okay.
which I don't want to get too technical, but is a higher standard than your regular court case.
Well, I think you have a battle between parents to some extent, where one parent is in favor of his or her spouse now becoming the other parent,
Right.
and then you have the other parent who's contesting. How is DCF involved, and what are they doing as far as arguing or being part of this?
In this kind
in a
of
contested
situation?
situation?
So again, DCF doesn't have to be involved in that adoption. If often there is DCF involvement, though, in terms of what they're looking at, if they're investigating the both parents. Again, it doesn't happen that often because for a multitude of reasons, even the parent just is digging in their heels. And then you can imagine it's hard for people to say, oh, sure, I'm going to give up my parental rights, even though they may not have exercised them for years and years and years. People are very, attached to their children, even if they're not attached to their children. So there's a fear for people as well that, well, if I come in and I object to this and fight it, now I am going to be held to some standards, and I'm not prepared for that. And I think that's why many people don't come. So the chances of it becoming a very contested matter is not that great. This person has not tried that hard for often many years. And the likelihood of them coming in and now really trying to assert their rights and trying to demonstrate that they have any right to be in this child's life is not usually a winning argument from their perspective. But DCF doesn't have to be involved in that situation.
Okay. You mentioned a home study.
Yes.
An investigation. What is the home study? How is that built into the law? What is it designed to accomplish? What occurs?
Okay. So the home study is, by statute, the DCF is required. That's the agency that the state is charged, or the adoption agencies. Okay. So, but if you do the adoption agency, that's usually more expensive. It's usually a private pay, and you're usually already a client.
Okay.
So in either event, if it's DCF or an adoption agency, they are. It sounds terrible. It's frightening for people to have to go through it, but they're not coming in to make a choice of who on this street's the best parent. That's not what it is. And many people may feel, well, I'm not rich, or I'm not, I don't have a beautiful home, or I can't provide, the best of the best. And that's not what they're looking for. They're looking that you have a safe home, that you have, accommodations for a child or children to be added to that. And, you don't have a criminal background. Those are the things that they're looking at. But they also want to explore your motivations, making sure that you're prepared for all that comes with adopting a child, that it's not always joyful. I mean, raising children is difficult.
Sure.
And so often children may come with a variety of issues that you might not see in a natural born situation. So counseling is often helpful, but they just want to make sure that you've thought of these things. They want to know if parents are on the same page, right? That they sort of agree in terms of how the children are raised or to be disciplined and whatnot. But it's not the third degree, right? I mean, DCF wants you to be able to adopt children, and the agency as well.
So is there a report that's filled out?
Yes, they fill out a report. So it can be, a couple of visits to the home, interviews, and it's a big piece of paperwork that you have to fill out as well in terms of, who you are, and they might look to some collaterals that other family members to get references, friends, neighbors, etc. But yes, they file a report with the court and kind of puts that all out there for the court to see as to what the history of the child was, how they came to be in the situation, and how this family is going to be what's best for the child. And in all adoptions, too, that the child has to be in the petitioner's home for at least 6 months. So we've had an opportunity to, bond and develop. And so with DCF or an agency, it might be, pre-adoptive placement. So before the adoption were to go forward in the court, they do have to be with the petitioners for 6 months.
So you've got 6 months. You've got the home study. You have, which can take, I'm sorry, how long a period?
So you're likely to get in a little quicker with an adoption agency than with DCF. I think DCF is required to maintain some time limits, but often with bureaucracy it doesn't happen. So it can take 3 to 6 months for DCF to complete its home study. So sometimes you kind of get that going. You can reach out to them and say, let's start the home study even kind of before the adoption is going forward.
Other requirements that have to go before the judge, before the judge makes the...
Yes.
What else?
So just those things. You're going to have your petition, you have an affidavit from the petitioners, you're going to have the consent, you need to have their birth certificates, things along that, a stack of papers that we all have to file. But they do the home study, they check the National Register of Missing Children, make sure this isn't an abducted child. DCF will check the, you can file as typically a father, you can file a parental responsibility form. So if you felt that you were in a relationship where a child might have resulted, you can, file that with Department of Children and Families at any point, right? And say, I'm acknowledging a paternity or potential paternity. So DCF checks that as well to see whether there's anyone so that they know who else might need to be notified if that's the situation. One of the issues that people have sometimes is when we talked about consent, so we need parental consent, we need the child's consent, actually, if they're over 12. We need the child's spouse, if there is one, and the consent allows a mother with a child born out of wedlock to be the only one that has to consent. She is then asked if she has the father's information to provide an affidavit with that to give notice. But if she declines to do that or claims not to know, unfortunately there is a situation where that father might never get notice. So if a father feels that he might have had a child, that's where he can try to protect his own rights by filing with that registry with DCF. So DCF checks that, sees if anyone else needs to be notified.
Is that the acknowledgement of paternity?
Right. Acknowledgement of paternity is typically something different. If they're on the birth certificate, those are some of the things that are clues. But it's really more for the parent, the father who doesn't really know.
Now, you're talking about the consent of the child. At age 12 and up, how does that consent manifest itself to the judge? Does the 12-year-old come up and speak before the judge, or is there a guardian ad litem associated?
So the child would sign, and it's notarized. The child signs the petition right off the bat. So if you had a situation where the child could not give consent, and we think of you need to be 18 to truly give consent to things, but if the child were unable to consent because of special needs or something, mental capacity was not able to do that, I think you would at that point ask for the court to appoint a guardian ad litem to sort of a substituted judgment and give the consent for that child.
So does a guardian ad litem get become involved quite a bit in these proceedings, or not so much?
So I would say not so much. If you're in a contested case, then in termination of parental rights or a care and protection proceeding where the ultimate result could be the termination of parental rights, then the parents are going to have an attorney appointed, and sometimes the child would get a GAL and or an attorney appointed in that situation. So.
Okay. So we've gone through all of these processes, the petition, the home study. We've gone through the 6 months. We've gotten the consent of parents, the consent of the child. It's not now before the judge. How long a period? How long has all of this taken, typically?
So fairly quickly, certainly if you have the consent, or if you're just doing it by notice. So again, kind of the blood relative step-parent situation. It's not very long. If you get the home study waived, so first thing we do is we file our petition. The court then is going to require notice, which again we try in hand, or it could be publication. So your return date, the date by which somebody has to object, is probably maybe 5 weeks out from when you file, in that neighborhood. Because again, your timing, you have to publish in 3 consecutive weeks, and it has to be in time so that they still could respond to it. After that happens, and there isn't probably within a day or two after the return date, if that other parent hasn't filed an objection, the court does its thing with checking in with the DCF. Most times they're going to waive the home study. If they didn't, you would then have to proceed with that, and that's going to add to your timing.
So all of the ducks, you have all your ducks in a row, could be a matter of 2 months?
Probably slightly longer than that until you get your hearing, but 3 to 4 is certainly realistic.
What's the judge's role at the hearing at that point?
They have to stamp it, sign off on it, but they have done all their approvals, they've read all the paperwork, and they're satisfied at that point. By the time I'm in front of the judge with the family, it is, like I said, a celebration. Cameras, you can bring your friends and your family in, and the judge will either take you into his or her chambers, or they'll close the courtroom to everyone. And their judges will sometimes put, depending on the age, put the child up on the bench with them so they can get that experience. And
that's when you see people smiling.
Yes, and the judges are happy, so it's a nice day for everyone when we get to that point.
Now, after the celebration,
yes,
is there an appeal period? Is there a period that we need to be concerned of?
So no. Okay. Because if there's been an appeal, so in that situation, you're talking about, termination of parental rights, technically dispensing with the need for consent of that parent. When that judgment comes, it's not an automatic adoption right there. So we have that, then the parent is likely to appeal from there. Right. So then that is extended. So they're not free for adoption until that appeal period has passed and gone through everything. So it's a much longer, arduous process.
More of an interlocutory nature of an appeal.
So nothing goes forward until they're completely legally free to be adopted.
What then what can the natural parent, let's say that they've consented, it's gone through to the hearing and the adoption's gone through. What are the natural parents' rights going forward at that point? Anything?
They really don't have any rights at that point.
Okay.
We can, and sometimes do, have adoption agreements. Sometimes that is part of a parent's willingness to consent, is to have some form of contact. Often that is a annual, maybe every 6 months, the adoptive parents will send a picture, a couple pictures, maybe tell them, what grades they might have gotten, or that they're in the band, or but it doesn't have to be identifying information of the adoptive family if that's not what they've agreed to do. Okay. So that's what's common. If there's been an established relationship between the child and the parent or parents, then you're more likely to have it where whether there's some Skyping or there's actual visits. Sometimes visits are supervised, and they might just be once a year. It might be a willingness to accept a Christmas present. So people can be very flexible in what they do there. Ultimately, that agreement does still need to be approved by the court.
But that's an agreement that occurs at the stage of the adoption proceeding?
So it can happen in any adoption if it's a contested, termination situation. The court can order it. But even in that situation, sometimes DCF will reach an agreement with the parents. And some of the reasons for doing that is you have a child who's kind of left in limbo as this goes on and on. They sort of have no, they're in the custody of DCF perhaps, and not necessarily the best situation, but it can be a long process. It can be an expensive process. So there's a lot of reasons for people to do that. Again, it would be inappropriate to entice someone and get their consent with these promises. The adoptive parents, you can come back in, but the really only remedy if you have an adoption agreement is specific performance. And the court is still going to be looking at the child's best interest. So if it's no longer in this child's best interest to have a contact with that parent, that can be terminated. Those adoption agreement could never be expanded. You could never, as a biological parent, come back and say, we have an agreement where I get a letter every 6 months. Now I want to come and see this child. That can't happen. The court won't do that, and they can't do that.
What if I've never, and we've got about a minute here, but what if I wasn't part of, as a natural parent, wasn't part of the process, but years have gone by and I decide I'd like to have some sort of contact?
So,
what am I?
Are you talking that now the child's an adult?
Well, that's a good point. Let's say the child is still a child, teenager, something along those lines.
They can't. I mean,
Okay.
I suppose you could go on your own and try, just as anybody could try to find you or look you up and whatnot, but they don't have any legal rights
But
to
as
that
an
child.
adult, that changes.
As an adult, the child then can, of course, also say, I'd like to meet, and that's what the bio parents could do also.
Andrea, I want to thank you for speaking with
You're
us here.
welcome. You're welcome. Thank
This
you.
has been great. This has been very, very informative.
Good. Good.
And as I always say at the end of these shows, please, if you have a specific set of facts that you're looking for answers to, please don't base any decisions on what you're hearing here. I would ask that you approach local counsel, someone with expertise like Andrea of Levitt Law Group in Chelmsford. This is why we have local attorneys to counsel you and to help you through these processes. So as I said, I'm Christopher Lilly. I thank you for watching, and I thank on behalf of Andrea Wells. I want to thank Andrea and thank you again. Good night.